Hello, everyone, and welcome back to Alt Legal Connect. This is the Ex-Filings, Expungements and ReExaminations Explained. My name is still Britt. I am still the Director of Education at Alt Legal and the Master of Ceremonies for Alt Legal Connect. I am here to make sure you have a wonderful time, so let me know how I can make that possible. All right, so I'd like to show you this. Okay, all right, so while this is up, I'm just going to remind you, don't be a jerk. Don't be rude. Don't harass anybody. Don't threaten anybody. I don't want to have to ask you to leave, but I do have, I'm pretty sure, the best audience on the planet. I can't imagine that's going to be a problem. All right. We are offering CLE credit for this session through the state of California. And you can probably get credit if you're in other states. You can see our CLE FAQ for that. Let me know if you need that link. The requirements are I need you to be here present the entire time. That is 70 minutes. This is for live attendance only. I'm not able to give you credit for anything you watch via recording. I also need you to write down the code when I give it to you. Please don't trust yourself to remember it. Write it down because you're going to put it in the survey that you get in the chat at the end of the session. And if for some reason you miss that, I will also send out the links to the surveys in the email that I sent tonight. However, I will not tell you what the code is later because the entire point of the code is that you listened for the code. All right, so you'll put that code in the survey. So this should go without saying, but Alt Legal is still a legal technology company. We're not a law firm. We're not giving you legal advice. And the views that you're going to hear aren't necessarily our views, although they're the views of some really smart people. All right. As always, please use the chat, share resources, talk to one another, connect with one another. If you have a question for the panel, please make sure to start that with the word question so that it's easy for us to get those questions over to our panel. All right. Now I'm pleased to welcome our speakers, Tamara Rabenold, Britt Anderson, Charis Dorsey, and Eric Perrott. Let's start with our panel's moderator, Tamara, is the CEO of Vaudra International, a private investigations company that focuses on IP investigations. She's worked at Vaudra for over 19 years, starting initially as an investigator. And if you need some help proving non-use, make sure to enter to win her prize in the raffle, which is exactly that, an investigation. All right, next we have Britt Anderson, who's a partner at Perkins Coie, where he practices IP litigation and advises clients about trademark strategies. He focuses his practice on more established startups and on companies that are entering the US market. So definitely has tons to say about these things. Next, we have Charis Dorsey, aka the brand attorney. Circle R. She's an attorney specializing in, you guessed it, brands. She prosecutes trademarks and also offers brand enforcement services. And in her free time, Charis runs the Vision Foundation, an organization dedicated to helping those in poverty develop business ideas and start companies, which is super worthwhile. Right, finally, we have Eric, who's a partner at Gerben Perrott, where he handles trademark and copyright prosecution and litigation. Eric's really active with the ABA IPL, where he helps to prepare the next generation of IP attorneys. And Eric also has the distinction of having filed the very first expungement proceeding. But all of the attorneys on the panel have filed expungement or reexamination proceedings, and all of those have been initiated. And Tamara has provided evidence that's used for such proceedings. So listen up, they have tons of great things to say.
Okay, thank you so much, Bree. So we're super excited to be here today, and we've worked really hard to put together a information-packed session. as we talk about all things TMA. But before we get started, and to help our focus for this information-packed session, let's all take a deep breath together to reset our neural pathways and clear the mental slate for learning and understanding. Okay, ready? All right, everybody, big inhale. Okay, and exhale. All right, so we're going to kick it off with, this is our lineup. So Britt Anderson's going to kick us off, he regularly rides 100-mile bicycle races. He's going to start out by providing an overview of the procedures and components of expungement and reexamination proceedings. Then I will discuss the reasonable investigation requirement as part of your verified statement. And I also believe that life is better with a furry friend, hence the photo there. So adopt, don't shop. Eric, who Bree took your fun fact and shared it before I got to, Eric proudly filed the very first expungement proceeding back in December 2021, and he'll share some stats on the TMA filings to date and some key learnings thus far. And then last, but certainly not least, we have Charis Dorsey, who will cover strategies tied to evaluating which tool or combination of tools may be best when preparing to challenge that trademark. And of course, one of Charis's favorite pastimes is traveling to experience Pilates in different countries and states. Her most recent experiences include a hot Pilates class in San Francisco, as well as Ghana and Cabo. So that's incredible. So now I will pass it over to Britt. Take it away.
Thank you very much, Tamara, and good afternoon to everybody. This is a topic I enjoy talking about a lot. I've been involved with various kinds of issues having to do with trademark use on the register for a long time, and so this is an exciting topic for me. And I'm going to go ahead and advance to the first slide here. Before we talk about the expungement and re-exam proceedings specifically, I just wanted to give people a sense as to the total context of the Trademark Modernization Act. The non-use proceedings, expungement, re-exam, were just an important part of the Trademark Modernization Act, but there were some other elements too, to put it into context. It was a very exciting development in late 2020 when Donald Trump signed this into law. First of all, there was codifying the letter of protest practice, and many of you have probably worked with that. There was also a change in the long-standing 6-month interval for response to office actions, which was reduced to 3 months. And the rebuttable presumption of irreparable harm was put into the statute which resolved a circuit split. Another aspect, important aspect of the TMA of 2020 was that the Comptroller General is supposed to report to Congress on inaccurate and false applications by December of 2024. So you can kind of see that everything with the Trademark Modernization Act, by and large, was intended to sort of streamline the register, improve the integrity and things like that. And that's basically what the expungement and reexamination proceedings were about, is getting rid of some of the deadwood and freeing up the register for new trademark applicants. The additional context was that there was the TMA followed a post-registration audit program that had been run on a pilot basis by the USPTO since about 2016. Also, in 2019, there was an implementation of the U.S. Counsel rule, which basically required that foreign domiciled applicants and registrants appoint U.S. counsel for representation before the USPTO. So what is the expungement portion? Basically, the expungement has a specific use where a mark has never been used on some or all of the goods or services. It's available for Section 1, Section 44, and 66 registrations. Section 1 basically would be used by a U.S. applicant claiming use of the trademark. Section 44 is foreign priority, and Section 66 is through the Madrid Protocol by a foreign trademark owner. The expungement does not require abandonment. Basically, it's just non-use. So the normal standard for abandonment under 15 U.S.C. 1127 is not an issue. With all of the factual issues having to do with abandonment, this really kind of streamlines what the analysis is. Also, there's no evaluation of the intent to resume use. So in other words, you don't have that type of inquiry where a party can discontinue use of a mark for some period of time, but they intend to readopt it at a later point in time. None of that is really involved here. When and where can the expungement be filed? A petition before the director can be filed between 3 and 10 years after registration. In other words, you have to wait for 3 years, but any registration after 3 years through December of 2023. In other words, those really old registrations are subject to the expungement action up through December of 2023. The expungement may also be initiated by the director. And at the same time, and this is somewhat of a side issue in terms of the particular proceedings that we're talking about here before the trademark examiner, but the TMA also implemented a new claim at the TTAB basically for non-use, not requiring abandonment. In other words, the mark has never been used in connection with some or all of the goods and services. The re-exam is somewhat of a mirror image, but the important thing to remember is that the re-exam is applicable to marks being not in use as of a relevant date. In other words, when the statement of use is filed or when the application is filed and use is claimed. Re-exam is basically deals with that specific point in time where the applicant claimed use in connection of the mark in connection with the goods and services. That could be, again, either the Section 1A filing date, or it could be the amendment to alleged use filed later with a Section 1B application. It's not available for Section 44 or Section 66 Madrid Protocol filings. Again, those particular applications don't actually require use in order to attain registration. So re-exam just by operation would not be applicable to that, to the declarations that are filed with those applications. Again, when and where petition before the director can be filed between 1 and 5 years post-registration, or may be initiated by the director. My colleagues will talk a little bit about the proceedings that are initiated by the director. The non-use claim that is basically intrinsic to re-exam, it already exists at the TTAB. It comes in various forms. Most commonly, it's called void ab initio, and it is a claim that's been used over a long period of time, basically alleging that there was no use at the time that the declaration was filed, alleging use with the USPTO. Non-use petition technical requirements, and I'm just going to go over these as far as the elements of the petition, because my colleagues are going to address these in more detail. First of all, the petitioner's name, domicile, address, and email. We'll talk about who can file these in a second. There's a filing fee of $400 per class. That fee was talked about considerably as far as what it should be, and it finally settled in roughly there. And I believe, if my recollection is correct, it's basically the same fee as a non-use cancellation per class. The U.S. registration number, you identify the challenged goods and services, full or partial class. There's a verified statement of reasonable investigation, and this subject is also going to be treated by my colleagues in quite a bit more detail. They're going to drill down on in it. I'll just say at this point that that verified statement of reasonable investigation must relate to an investigation that's comprehensive and targeted to finding non-used goods or services. That's essentially right out of the rule. The documentary evidence of non-use must provide the results of the investigation. In other words, there has to actually be specific physical documents associated with the petition for of non-use, indicating what the results were in the searches. And then there has to be an index, and that's going to be covered in more detail too. There has to be an index associated with the petition, which basically compiles and associates the exhibits. This diagram here gives you an overview only. It doesn't describe every detail of the timing or of the particular actions at each stage, but it's important to consider the proceedings overall. First of all, the petitioner files the petition with the evidence, pays $400 per class, roughly, and my colleagues are going to talk a little bit more about the timing here, but the examiner then will issue the notice of institution or a 30-day letter if the petition is inadequate. And the notice of institution comes along with an office action issued to the registrant, basically to show evidence of use or excusable non-use, or to delete certain goods, or the registrant may not respond at all. If the registrant responds by deleting goods or does not respond, that terminates the proceeding. If the registrant responds with evidence of use, but it's considered to be unacceptable, or some other aspect of the registrant's response is unacceptable, there will be an office action issued. Call that a final action. For those of you who do prosecution, this is very similar to a specimen refusal. Essentially, you get a chance to submit a new specimen. You have to meet the requirements for submitting that new specimen. And if your further specimen that you submit is inappropriate, then you're going to get a final office action. It's really the same type of flow. Once the examiner issues a final action, then the registrant has a chance for a request for reconsideration. And we'll talk about the timing of this in a second. The registrant, if the registrant is dissatisfied at the end and has not proven the use of the mark, then the registrant can appeal to the TTAB. Who may file? Let me cover this here because this was a big concern for the USPTO in both the draft rulemaking and then finalizing the rulemaking. Basically, what turned out here is that there is no requirement to identify a particular trademark owner or claimant in these proceedings. They can be filed in the name of a law firm. So that's an important aspect of it here. It really is not, ultimately, it's not an adversarial proceeding. It's very important to keep in mind. So the new non-use proceedings, past non-use may be difficult to establish. That's particularly the case with the re-exam proceeding where you're dealing with some point which may be several years in the past. Current non-use evidence has to be part of your prima facie case. Multiple types and sources of evidence should be included. One thing to focus in on is that improper or fraudulent specimens included in the prosecution file are of particular interest to the USPTO and can allow an inference of non-use. The documentary evidence itself should be relevant to fraud, should be provided in the index of evidence. And then your web and search results, even if negative, should be provided in the documentary evidence of non-use. In other words, if you didn't get any results, those should be included. The USPTO institutes the proceeding by posting the petition in the public file. So in other words, whatever is happening with the proceeding is part of the file, the prosecution file that you look up, the file wrapper, if you will, that is accessed through TSDR. Following the substantive review, the examiner will issue either a 30-day letter to the petitioner if the petitioner hasn't alleged it had made a proper petition, or a notice of institution, and the office action setting a 3-month deadline for a registrant's response. This is a 3-month deadline. That's important to keep in mind, because if you're comparing this to other proceedings, such as a non-use cancellation before the TTAB, that may become an issue. It's a fairly long period. The registrant can get a 1-month extension with payment of a fee to respond with the use evidence. That may be very relevant if there are many, many items in the particular description, such as clothing goods or other kinds of merchandise where sales may be more erratic over time. The determination of institution of a proceeding is final and non-renewable. In other words, the examiner's determination that the proceeding should be instituted is basically within the examiner's discretion, and there's nothing that the registrant can do anything about it. The examiner will not institute and instead issue the 30-day letter to petitioner if there is an element missing or the examiner plans to institute proceedings. But note that if you don't put enough documentary evidence into the file to begin, you can't supplement it after the proceeding has begun. In other words, once you get a 30-day letter, you're not going to be able to add more evidence into the file. And the prima facie case, importantly, has to be made as to each good or service challenge. So in other words, hypothetically, you could make a case as to one good or services, but something else you're targeting, you might not succeed. The registrant's response the registrant must respond within 3 months. The time for the response can be extended by 1 month, as I said. If there's either no response or request for extension is received, proceeding terminates. If the relevant goods and services are canceled, if response is not substantially complete, examiner again will issue a 30-day letter to the registrant. The registrant's response has to contain evidence of use before the filing date of the petition, the verified statement, or you can delete some or all of the challenged goods or services. With a re-exam, the evidence of use in commerce with goods and services on or before the relevant date to comply with the 1A requirement. And the response must be consistent with use in commerce, but it's not limited to compliant specimens. In other words, you can show information indicating that goods were sold with the goods, and you don't have to actually show a specimen on that date. And then the final action response, if the response fails to rebut the prima facie case, the final office action issues. It includes an examiner's decision and maintains requirements as to any or all goods and services. The request for reconsideration must be filed within 3 months, and/or the request for consideration does not extend or stay the appeal deadline. In other words, it's just like an office action where you still have an appeal deadline at the end. After the response, if the registrant has rebutted the prima facie case, a notice of termination issues. So in other words, at that point, if the registrant has produced the evidence of use, the case ends. And there's no further action that the party that initiated the petition can take. If the registrant fails to comply or rebut, the notice of termination issues. In other words, it's pretty clean. There's no further proceeding that can take place. Important things with estoppel and co-pending proceeding. After termination, no proceeding may be filed on the same goods and services. In other words, basically, there's no, if there are two proceedings that are lined up and one is filed the day after the other, the second proceeding essentially has no action and is not going to be initiated. While the proceeding is pending, no proceeding may be instituted for the same goods or services. Suspension is important because sometimes these proceedings are going to be filed and they may be suspended based upon civil actions or on TTAB proceedings. Examination on other applications may be suspended in view of non-use proceedings. In other words, what's happening with one particular application examination could be a basis for suspension. In other words, if you have applied and then you file a non-use proceeding, you may want to suspend your application to wait the outcome of the non-use proceeding, particularly because they do take a fairly long time. And that's it.
Okay, great. Thank you so much, Britt. As he mentioned, a verified statement of a reasonable investigation is one of the TMA's technical requirements. So we are going to dig into that. First off, what does the USPTO consider a reasonable investigation? In the rule, it's been defined as one that produces reliable and credible evidence of non-use at the relevant time. The TMA also states that as a general matter, a reasonable investigation is greater than a single internet search, but less than requiring you to search every possible source. Now, deciding how much evidence is reasonable can be a challenge in any investigation. At the TMA's leadership meeting last year, the USPTO took the stage, and I really like what Deputy Commissioner Amy Cotton had to say. She acknowledged that early on with the TMA petitions, there was a time when evidence overkill was a standard to establish your prima facie case. Now that we have a year under our belt and the USPTO has fine-tuned their process and handled more of these petitions, she said that if enough evidence is inferred, it is sufficient. In considering where to find evidence, the TMA gives you some guidance, as shown here, for sources of information that are reasonably accessible and can be publicly disclosed. Most of these are obvious and may be things you already do in your initial due diligence. One thing that I want to point out as it relates to the registrant's marketplace activities is that the evidence can include any attempts to contact the registrant or purchase the relevant goods or services. Going straight to the horse's mouth, assuming you can find the horse and said horse is reasonable and responsive, is often an incredibly useful avenue for information. If you do this, always contact the registrant as a member of the public or consumer in a manner consistent with this entity's normal course of business. For example, an email response directly from the website's contact email or web form. Now, if you attempt contact and the contact methods don't work, like getting an error through the web form, the email address is invalid, or the phone number reaches a number that's been disconnected or no longer in service, this information is also valuable. In any of these instances, these outcomes should be preserved and captured as evidence. Now, one thing to keep in mind related to direct contact with the other party. There are published bar opinions in states like North Carolina, Arizona, and Colorado that speak to the value of what could be considered misrepresentation or undercover work as it relates to IP investigations, and that a lawyer may advise, direct, and supervise the use of misrepresentation if several factors are met. If you or someone in your firm goes to the horse's mouth, you should be cognizant of how far any dialogue goes and your comfort level based on the rules of professional conduct, especially since this evidence will likely be included in your verified statement and index, all of which will be published and publicly available in tests. I also wanted to mention that I'm here as a subject matter expert and not because the USPTO requires you to hire a PI. Please keep in mind that if you do decide to hire an investigator, you can reference the investigator's results in your verified statement without disclosing information that would waive any applicable privileges. And regardless of who handles the investigation, when explaining the scope and including the testimony in the petition, be sure to include the documentary evidence. For example, if you include the investigator's report, also include all of the related documentation and screenshots of the findings as part of your index. As Britt mentioned, here are the components of building your prima facie case. It's important to submit multiple types and sources of evidence that create inferences of non-use. Next, I'll cover some tips to proving the negative, which are consistent with guidance from the USPTO for building your prima facie case. As Deputy Cotton said that an overkill or overpapering of evidence is no longer necessary, I'd suggest that you find all the evidence you can, and if it seems excessive, narrow it down to the most compelling that clearly illustrates your argument. In the process, you may find evidence that leads you to reevaluate if a TMA filing is the right course of action, and Charis will talk about possible strategies to consider in a bit. All right, so first, when talking about non-use, and Britt mentioned this as well, for your no-hits evidence, it's important to capture screenshots of the negative online search results. If you state that a Google search was conducted for X trademark on a particular date and no relevant results were found, you provide screenshots as proof of that negative result and include them in your index. And please know that if you or whoever conducts the searches state that relevant results were not found, but the index doesn't include the digital proof, the USPTO will most likely send a 30-day letter so you can fix this gap in your index of evidence. When they do, new evidence will be accepted, as Britt mentioned. So it makes it critical to capture proof of the negative results on the date you reference in your petition. We recommend using multiple search engines in your research. I list a few options on the slide. Here's the time when you may try a few platforms and then decide which search results are the most compelling. And particularly if you are seeking evidence of non-use between certain dates, narrowing results by a custom date range may be helpful to demonstrate research into that time frame when the mark was claimed to be in use. Most search engines have a way to do this, whether it's under tools on Google or settings on DuckDuckGo, as shown on this slide. I'm sure everyone's familiar with the Wayback Machine or archive.org to see what historic views exist for a subject's website and whether the mark appeared on whatever date. Cachedview.com comes in handy too, as it gives you the option to check Google's web cache, archive.org's cache, and visit the live site all from one place. Now, be sure to flesh out other third-party results, especially if you find hits of seemingly similar use by third parties. In your statement, explain that you found X use, but it is tied to a party not related to the registrant, and include the relevant documentary evidence. Now, is your registrant based outside the US? What kind of US presence do they have, if any? Think about website and social media. Is it in English? What currencies are offered? If it's an e-commerce website, can you add the item to your cart? And is it possible to enter a US address? Whether you find use of the trademark or not on this site or on a site in another language, your index should include the documentary evidence of the website in the native language, followed by the translated page, citing the source and date of the translation. And this can be super simple, just by capturing the page after running it through Google Translate as captured on whatever date. As for current non-use, whatever the goods or services are, you want to find the biggest platforms related to that product or service and search for results. For efficiency's sake, searching Google Shopping is a great way to get a wide array of hits in one place, so you can see what other platforms may be worth further review. If it appears that sales are limited to outside the US, check the top e-commerce site in that registrant's country. And does that platform then kind of evaluate, does that platform cater to the US market? Does it appear that they ship products to the US? If not, it could help prove that the product is only sold outside the US. When it comes to exploring more specialized channels or resources, you need to look where you would expect to find this product if you actually wanted to buy it. If the mark is for an app, check the app stores. If the mark's tied to alcohol or tobacco, check the public cola registry. When citing an industry-specific resource, briefly describe what it is and how it relates to that relevant industry in case the USPTO examiner isn't familiar with it. And of course, for design marks, conducting reverse image searches to see what other sites may pop up is a great first step. And depending on what you find, this may take you down another interesting road. And into the world of bad specimens and fraud. These tend to overlap a bit, although digitally altering a stock image may not rise to the level of fraud on its own. Depending on your situation, you may decide to start with this specimen, as at times it seems pretty obvious that it's a stock photo from somewhere. And also, if you find the image on a subject website, you may be able to check the file properties for useful leads. At the Intel leadership meeting, USPTO Deputy Commissioner Cotton went in depth about recent findings tied to specimen farms, which was a term that was new to me. But evidently, specimen farms are on the rise, and I imagine they will continue to grow with implementation of AI. And the USPTO is appreciative if you can call this out as part of your verified statement when you find evidence of such. I've listed some potential indicators such as dummy text, broken links, and incomplete contact details. As more on fraud relevant to non-use, public filings or sanctions that discredit the registrant's attorney are a start in raising the fraud issue. If you have a sneaking suspicion based on your image searches that you're dealing with a specimen farm, a trick to use is, find a 5 to 7 word phrase that seems more unique, put it in quotes and run a search on it, just on the general Google search, and see what other sites may pop up. We also always check the privacy policy or terms of service, which may even cite a different website or entity that could give you another lead. I list a couple other things to look for, and just remember that whatever you find, be sure to capture your digital evidence to use in your index. In thinking about what is evidence, here are a few things to keep in mind. Always start with your objectives and the need to document the presence as well as the potential absence of what is of interest. Make sure that your screenshots are time and date stamped at a minimum, and ideally also include hash information to be legally defensible in court, even if that's not really needed in these TMA proceedings. I've listed a few resources, including Hunchly, which is what we currently use. As you find and capture the digital evidence, keep your index in mind. The USPTO gives you models to follow, so decide on your format and name the files accordingly to save you time when you're preparing to reference it in your verified statement. Or if your investigator knows that you plan on doing a TMA filing, they may be able to help you with this. Certainly, evidence doesn't do anyone any good if it's not legally obtained. An easy example that doesn't really apply here, but it's one of my favorites. If you go dumpster diving for evidence, you want to make sure that the trash can is on the curb and not private property. The silver bullet doesn't do you any good if it's not admissible. For additional resources, we use a combination of open and closed sources. Some I've already mentioned, but depending on what you're trying to uncover, I wanted to provide them on one slide as reference. And also, if you visit Vaudra's sponsor booth, I also have a trademark use research worksheet available for download as a PDF that includes all of these resources and others, along with a general framework to organize your own investigative research. So now I will pass it over to Eric to cover current TMA trends and what else we've learned from the filings to date.
Thank you so much. And yeah, I think that we've gotten a lot of great information about why, how to file these, about what goes into them. But I think what I'm going to talk about for a little bit is, what have we seen so far from the actual filings that have been made? As I had the privilege of being the first to actually file one of these and get it enacted by the U.S. Patent and Trademark Office. But I actually got involved with this a little earlier than that with the House Judiciary Subcommittee. They did roundtables trying to figure out exactly what should go into the TMA and what works, what doesn't. And so getting to see this kind of evolve from what it was to kind of what it currently is and kind of the problems they were trying to solve has really interested me, and to kind of see how they work and kind of see what the year in review has looked like over the past year. And so we're going to look at who the petitioners are, who are the respondents or the registrants. We're going to look at how long it takes, which Charis is going to talk about, how we make the decisions of how to recommend one of these to the client or go one of the more traditional routes. And then also what kind of trends we're seeing even in the short amount of time that these have been available. And my primary source right now is the USPTO's page on petitions. And so they list every single one of them on this page. They may not be posting all of them in real time. I think they're supposed to be, but just kind of keep in mind that my numbers are coming from this page. And there are likely some data providers that are also kind of have more up-to-date information. So check those out too if you're interested. But this is kind of my primary source that I'm working on. And I recommend checking it out because it does have every single time a petition is filed, this is where they're being posted. So far, and this was as of the end of January, 207 petitions have been filed. The first one was the one I did in December 21st, and the most recent one posted is the Rucker on December 2nd, 2022. Of those, 45 have resulted in either a canceled or amended trademark registration. As Britt mentioned, if you don't respond to a partial expungement, then it'll be canceled, but you can also give up that part that's being challenged and say, well, okay, fine, I canceled those goods. That will also resolve the expungement and still keep the rest of the goods that weren't challenged. And so we have seen of these targeted applications, or sorry, these targeted registrations, that 46 of them have been Chinese registrants and 108 have been US registrants. If we look at some of the reasons why the TMA, the Trademark Modernization Act, was passed in the first place, it was this idea that we have an influx of applications that never should have become registrations, that either the specimens that were provided or the list of goods and services did not match what was actually being provided in commerce. And there was no real easy way other than a petition to cancel to get rid of these deadwood applications that were here, or these registrations that didn't have any actual use in the marketplace. And then a number of other foreign registrations that had a laundry list of goods and services that unlikely to ever have been used and now can be kind of disposed of. And so what I thought originally was that, oh, we'll see a ton of international filings being targeted by this. But when you look at it, that's not actually the case. In fact, half of them have been against US registrants, which I thought was really interesting because only 22% of those were from China. And when you look at a lot of these filings and where the false specimens are coming from, undeniably, a majority of them are coming from China. And I don't think that that's disputed. They come from everywhere, but I think the majority of them are still coming from foreign applicants. But a lot of these were targeting US registrants. And of those, we have 7 instances where the USPTO actually accepted the registrant's response and said, okay, we're not going to actually delete anything from the registration. And of the 207 petitions that were filed, 57 of them so far were not instituted. And these are for reasons that Britt and Tamara went over to begin with, that they didn't include enough to prove a prima facie case. And if you look at that 57, that is a non-refundable, at least $400 fee that is going straight into the USPTO's pockets. And it is simply not instituted, and it is not something that you can even appeal. That is a non-appealable distinction if something is not instituted. You can refile, and several people have, but in that case, it's not something that you can argue at the Patent and Trademark Office and say, well, this should have been instituted. That is of the sole discretion of the petitions office. And what we're seeing originally was that people just weren't responding to these. Of the first instituted expungement petitions and reexamination petitions, many of them simply went to the equivalent of a default judgment and were canceled. But now we're actually starting to get responses. And of the ones that have been filed so far, we've seen about 40 responses, some of them voluntarily canceling part of their marks, but other them actually responding with evidence of use. Some of them successful, some of them less successful. In one of those cases, and this goes to one of our questions that we got about how do you prevent anti-competitive use, but I think another question that I had was, well, what happens if someone just simply files fake specimens in response to a non-use proceeding? And this actually has happened, or at least the USPTO has issued an office action saying that this might be happening in at least one case. And This is a foreign registrant who responded through a U.S. attorney and said that this mark was in use, and they provided additional specimens. Well, the Patent and Trademark Office has a database of specimens, and they found two that looked awfully similar to each other. You can see from this photo, they're not exact. And so I think there could at least be some arguments that this might just be the same manufacturer, but this is the same product, just with a different label on it. And so they have asked for additional, they issued a final office action saying, we think these may be digitally altered in response. And so that's something that the Patent and Trademark Office is paying close attention to. And they are issuing refusals if the responses that they're getting don't meet the requirements of the Patent and Trademark Office the second time around. Other trends that we're seeing is in institution time, that it's currently taking about 30 to 60 days. The Sparkle proceeding was filed in November 21st. 30 days later, it was instituted. But the most recent one, the Rucker, we're looking at about 60 days. And on average, it's looking to be about 45 to 60 days. And that's going to be important when Charis talks about what do we recommend? Because timing is a big part of that, for me at least. Because if I'm telling a client you can get something from the Patent and Trademark Office, but it's less, it takes 60 days to be initiated and then 3 months of response time. We'll talk about that, but that actually is an important thing to consider. And there's a number of things we're seeing over and over again of common reasons for non-institution, meaning that they said this did not meet that prima facie case that Tamara talked about. The evidence wasn't there. And you can see as an example that this one didn't have an itemized index. It did not include screenshots of the webpage evidence that they provided. And so they ultimately said that it did not meet the requirements to enact this. Another one, that the investigation consisted solely of a current search of the registrant's website, and that was not enough. It needs to be past non-use in addition to current non-use and the other things that Tamara had mentioned. Another one to be, this is something that Britt mentioned, is that you have to be careful of which one you choose, whether it's a reexamination or expungement, because a reexamination has to be about the relevant date. And in this case, that was July 1st, 2022. They did not provide information that it wasn't in use at that time. So you have to pay close attention when you're filing these to ensure you're actually claiming non-use in the time period that is required under the petition. And we've seen, these are the 7 successful responses that I was able to find, 3 of them all owned by the same person, where they were able to provide additional information and provide additional evidence that supported that they were still using the mark on all of the things that were being provided and that they had in the past. Some examples of this are a trademark licensing agreement. So the V-Smash owner provided evidence of that they licensed the mark to someone, and that that use of that licensed mark was evidence that it was in use and that it continues to be in use at the time that they said it was. They provided ad reports, invoices, things like that. Over 287 pages of evidence. So when you talk about kind of the kitchen sink of evidence, I think a lot of these really did provide that. Because another one, I believe, was 239 pages of evidence from Evoke. And so you can see here's one of the pictures that they provided, clearly showing the trademark, and then with a wall panel. And so this was evidence that they provided. Another one, you can barely see it, but that says Comicsgate Comics. They provided a declaration from one of their licensees who was allowed to put this symbol on their book as they were sending it out. And so that was evidence that was accepted. And the 11, that's how I'm going to say it, provided evidence as well that they were providing promotional advertisements through Facebook and through a variety of other ways to overcome the refusal from, or the petition, and to say that we provided all of this, we always have. And that was enough to overcome the petition without any changes to their current registration. The final thing that I'm going to talk about, and I realize I'm getting a little bit low on time, but Britt mentioned that there is a director-initiated proceeding. And I think that this is important because until the Trademark Modernization Act, there were very few ways that a trademark could be canceled, that a registered trademark could be canceled. And that was, through a number of ways of a petition to cancel, or not filing use petition, or sorry, not filing a renewal, things like that. All of that is different ways that a trademark could be canceled, but the Patent and Trademark Office could not actually cancel a trademark once it had been registered. But in this case, the director can actually bring an ex parte expungement proceeding if they find evidence. And that's kind of a very broad thing that says if they become aware of evidence, they could potentially use that to initiate their own proceedings. And currently we've seen this, and we've been kind of told behind the scenes that they're not planning on expanding it beyond this right now, but they are right now using it to essentially prop up expungement petitions and reexamination petitions that didn't quite provide enough evidence. It was not initiated, and then suddenly they'll say, well, we didn't initiate it, but we found our own evidence. So here's all the evidence we found. We are initiating it now. And that actually happened in the first one that I filed, is that I had provided evidence for about half of the goods, and then they filled in the gaps and provided it for the other half. And so I think this has a lot of potential, especially in the context of all of these applications that have gone through to registration that we're later seeing had a lot of doctored specimens, had a lot of other telltale signs that we in hindsight can see potentially are a huge drain on the USPTO's ability to kind of predict who's going to renew and things like that. So I can see a potential use of this being that the PTO has more flexibility to actually challenge applications that never should have registered in the first place. And I think that's a really kind of interesting thing to think about, but I will hand it off to Charis to wrap things up with some strategy.
Real quick, before we do that, I have a code for you. So get out your paper and your pen to write down the code. Your code is the number 9, the word non-use, which we all know is a word. I'm not sure if it's actually a word, but we think it's a word. The number 1. So that is 9, non-use, 1. Beautiful. Thank you. Carry on, Charis. We have about 10 minutes remaining.
Perfect. Thank you so much. And I will keep this pretty quick, but I did want to just hop in and talk to you all about strategies and scenarios for when, in the grand scope of trying to take in all of these tools, how do we use them, and what is the most appropriate time for using these new tools that have been introduced by the TMA. As of now, we have about 5. So the first one, of course, will be expungement. That has been introduced to us as a new resource that we can utilize. Reexamination is another. One that we discussed lightly, but is also a valuable use or a valuable resource for us, involves letters of protest. And then, of course, we'll still have our traditional cancellation proceedings and opposition proceedings. In the space of us looking at the new resources, one of the biggest questions will come down to, are we trying to challenge the substance of the mark itself or the application itself? And so when we're speaking of the application, we can get into conversations around use and non-use. But one of the things that I really do appreciate, and I think that this will be an actual value add to attorneys who have clients who hold trademark registrations and are coming upon new applications that are being submitted that infringe on those rights. The letters of protest have now been, we've now seen a shift where before we could kind of send in a letter of protest and kind of go into this big dark hole, if you will. We'd hope to get a response back from the examiner, from the director in time before the application registered. But now what has happened is they've essentially implemented timelines. So now the director, through the deputy commissioner, has up to 2 months to give us a response on those letters of protest. And one of the biggest benefits to it is that is non-reviewable. So in the event that we do come across new applications that are infringing, instead of having to initiate a cancellation or an opposition proceeding as we would have in the past, we can now submit this letter of protest so long as it's before or up to 30 days post-publication. We now have an opportunity to participate without necessarily having to get the client involved. So we'll talk a little bit more just about other strategies and just the triggers for when to decide if reexamination, expungement, or alternatively letters of protest, opposition, or cancellation make the most sense. But the biggest factors to consider in all of this are going to be timing, involvement, cost, and the evidence. In relation to timing, of course, the biggest question is how much time do we have to bring forth a challenge, and how much time will it take to overcome that challenge? One of the things that we think about here is with reexamination and with expungement, there are some time constraints as to when, or certain limitations as to when we can bring forth the claim. Sometimes it's not ripe enough just yet for us to bring forth a challenge, but on the inverse side, sometimes the application is still pending. And so in the space of that, we need to determine what resources make sense, just opposed to the phase or the stage of the application or registration. So just from what we can do before registration, we have our letters of protest before publication. And really, I add the asterisk that it's 30 days from the publication date. That generally speaking, after that point, a letter of protest will not be considered. And of course, we have oppositions during the publication phase as well. And then what can we do post-registration? We have the expungements, which Eric and Britt have mentioned, before. But with expungement, the application, the registration would have had to been on file for at least 3 years. And typically what we see is the range between 3 to 10 years post-registration for us to have the window of bringing forth an expungement proceeding. And cancellation, we have within the first 5 years of registration. And then typically beyond that point, for typical issues such as 2D likelihood of refusal, descriptiveness challenges, and then beyond that point, you can bring it for more substantive issues as it relates to the application, such as a basis for fraud, for example. And then we have reexamination, which needs to be brought within the first 5 years as well. So in the space of you determining which tool makes the most sense, it's also important for you to navigate or explore where do you stand within that timeline. The next question or next thing to be factoring in is involvement. In the space of involvement, one of the biggest questions that we're going to have is in relation to how involved does the client need to be. And in the space of involvement, we have the traditional meaning of what involvement would be, which is the client being named as a party, and if the resources are available would make sense for, or if based upon the resources that are available, if it's even necessary for the client to be named. And then on the alternative side of that, is it a thing where the applicant or your client needs to be involved to preserve their interests, for example, as fully engaging in litigation? With letters of protest, expungement, reexamination, in many cases, the client can remain anonymous when you're bringing forth those challenges. And then in that space, you're allowed to protect the client's resources, both in time and money, time and cost, as it relates to actively participating in the proceeding. Another factor to consider in terms of involvement is how long it would actually take, which will get me into, how long it will actually take, and from which will be quicker versus which will be more involved, or less involved versus more involved. Letters of protest, of course, are going to lead you to a space of being less involved in the proceedings. Again, you can submit the letter. At that point, it turns the facts over to the director or the deputy commissioner to review the facts and then make a determination. But beyond that, and you submitting forth or preparing your actual arguments as to why the application should or should not be submitted or approved for registration, rather, the USPTO doesn't require you to go back in and refute or further defend your position once the letter is submitted. And then you have like the expungement and the reexamination proceedings, which in the space of this, there is a factor of involvement and involvement, which when we're looking at it from the bigger lens of how involved the client should be or will be in this, there's a factor of research, and in the space of research, how long will it take to prepare the actual arguments or the actual expungement filing or reexamination filing, as opposed to when we're submitting forth opposition claim. So sometimes when we're getting in the space of determining which is going to be the most cost efficient, most beneficial to the client, we have to also consider, would it be more cost efficient to turn the matter over to discovery? And in the space of turning it over to discovery for facts and collecting the facts and doing the research, or would it make more sense or if we have a readily available resource or data pool for the evidence already, if it makes more sense to just proceed forward with expungement and reexamination proceeding. And then, of course, more involved are going to be your TTAB oppositions or your cancellation proceedings. And then the other aspect is going to be cost. Is there any way to avoid the hefty expense of litigation? Of course, in the range of the cost, we have anything as low as, in terms of filing fees, $50 for a letter of protest, and ranging all the way up to the point of litigation, which can be costly. And at minimum, you're paying for the filing fees $600. Expungement and reexamination fees kind of rest right in the middle. But then when it comes to the time involved with research and collecting data, sometimes it may not be, it's sometimes more cost prohibitive to pursue that matter versus allowing an opportunity for the evidence to come to you by way of discovery. The next thing is it's going to be around evidence, and do you have access to enough evidence to support a claim for expungement and reexamination? And we've had quite a bit of conversation around this up until this point through Britt and through Eric as well. And then what we've seen throughout the process of these new expungement and reexamination filings being submitted is that over time, there have been clear lines established around what is permissible, what is acceptable, and in the space of that, doing your own research or determining whether or not you should proceed forward with the proceeding, expungement or reexamination proceeding. It is going to come down to what you're able to collect prior to, and what you're able to do just by way of doing your own due diligence and a reasonable predicate standard. We've seen fake and digitally altered specimens to the extent that we're able to identify that they're fake and digitally altered specimens. We've seen that has been successfully accepted by the USPTO, as well as a lack of internet presence being, especially for brands or registrants who claim to offer goods or services online. We've seen that work. But then sometimes there are cases where the product may not rest online, or the product or service may not rest online, rather. And in those spaces, it may be a little bit more difficult to find that digital or online footprint. And in spaces like that, it may be sometimes to the advantage of the client to just proceed forward with the opposition proceeding to allow the defendant or the applicant to then show and prove their actual use. But in the space of everything, you want to just make sure that the evidence, if you have enough evidence and you feel confident in the amount, you're not finding yourself in a space where it's an overage, and when I say overage, because I've also seen applications come up or that have been rejected because of it essentially being a data dump. if you're finding yourself in a space where you have a healthy supply of evidence, it may be in your best interest to move forward with a reexamination or expungement proceeding. But in the event that you don't have that, you may want to go forward with the opposition proceeding. And of course, in the space of the pros and cons of the proceedings that we have now, especially around expungement, the pros are that, there's no standing requirement. There's less exposure to the client. There's less involvement. And it also helps to clear the deadwood applications overall. But the cons can sometimes factor into the cost with no guarantees of a favorable outcome, time to get results, and then delay to the application process. As well, there's some unpredictability. Sometimes the facts that we think we know or the facts that we think that we have aren't sufficient to overcome the threshold that the examiners have, that the USPTO has established for granting an expungement or reexamination. As well, there's the inability to terminate the process once it's initiated. So once you submit the expungement proceeding or once you submit the reexamination proceeding, it takes a life of its own. So it's going to be difficult to recoil that and bring it back in once it's been submitted. And then also, there's no useful or challenge. It's also not useful for challenging more common issues of priority or likelihood of confusion. So in the space of you determining what makes more sense for you, just keep that in mind. And with the exception of letters of protest, typically the proceedings or the new tools that have been introduced by TMA won't speak to or won't lend itself as a resource for matters such as that. The perfect example, so I know that there have been questions around the use of cancellations as our tool to challenge an application just exposed to expungement. And truth be told, both are appropriate. My rule of thumb is typically going to be in the space of making a challenge. At this point, to the extent that there is an issue regarding the application itself, I would try for an expungement or expungement or reexamination before initiating a cancellation. But where you have some overlap, where you have some considerations around likelihood of confusion, as well as potential issues regarding the substance of the application itself, maybe both are appropriate. But in the space, there is a BB proceeding, in which case, as the facts had it, the cancellation proceeding was initiated, and it was actually November 30th of 2020. The petitioner essentially challenged on the basis of intent to use the goods and whether there was a bona fide intent to actually use the goods. And then the petitioner actually alleged that there was no intent to use, or there was any alternative an abandonment of use of the goods. In the space of this cancellation proceeding existing, a separate expungement proceeding was initiated on January 20th of 2022. And in the process of this expungement proceeding being carried out, there was a suspension on the cancellation proceeding. And there was a pending outcome of the expungement proceeding as of March 17th, 2022, before ultimately leading to a notice of termination, which was issued on December 8th, 2022. So in this space, we're getting a perfect example of how a cancellation proceeding, how an expungement proceeding can impact an existing proceeding, especially a cancellation or opposition proceeding. A cancellation proceeding that is pending. So in the event that you have already initiated a cancellation action against a third party, but you're now contemplating whether or not you still have the right or opportunity to use an expungement or reexamination proceeding, this example is this is a perfect example of how you can utilize it to kind of conserve some of the costs and conserve some time for the client. Thank you.
And that's it. And I think we're pretty much at time, or we have maybe a minute.
No, let's go ahead and let's just, because we are so close, let's go ahead and move into the post-session discussion, and we'll take the Q&A there. I know there were a few questions that showed up in the chat. But we have, why don't you take 5 minutes, everybody, take a quick bio break, get a drink of water, speakers included. You definitely need a break after that. I will see you all there in the post-session discussion at 5:30. So everybody come and join us there. Again, cameras and mics are preferred. I'm not gonna force you to, but we would prefer that so that it's as close to a face-to-face discussion as possible. But everybody do come join us for that. This is our last session of the day, but we do have mini games this evening. They should be really fun. You'll find that again on the schedule. You'll find the link for that. So I will see you in 5 minutes for the post-session discussion, which will take 20 minutes. And then I will see you at 6 o'clock for the mini games. All right. Thank you so very much, panel. This was really wonderful. We really appreciate it and it learned a ton. Thank you.
Thanks. See you in a minute.